Good morning.
Good morning.
Wow, well, a lot of people here today. My name is Peter. I'm a lawyer, and my office is just actually on this floor on Suite 215. And I basically do real estate, wills, and business law. That's my practice, and I've been practicing for about roughly 25 years now. So I've got a little bit of experience in these topics. And today, Tony and Sam has asked me to come in and speak to you guys about wills, powers of attorneys, and estates, and how they affect you when you are acting as an agent in a real estate transaction. So I will proceed and would first talk about what's the definition of a will and what's the definition of a power of attorney. Now, a will is a legal document to deal with your assets and properties, financial affairs such as the payment of debts and taxes, and also your children's welfare after your death. The will becomes effective upon your death. It's not effective beforehand. So it's only upon your death that the will is effective. Now, complementary to a will, another legal document is called a continuing power of attorney for property. I'm sure most of you are probably familiar with a power of attorney. How many people here actually had done a real estate transaction using a power of attorney? Okay, so there's been a few. So you're probably more familiar with the power of attorney. It's a legal document that deals with your assets and properties and financial affairs before your death, while you're mentally incapable of or physically unable to make decisions concerning your assets and properties. Once you die, or once upon your death, the continuing power of attorney for property is terminated. So the continuing power of attorney is effective while you're still alive, but for some reason you're mentally incapable or physically unable to make decisions. But upon your death, that's when the will becomes effective. So these two documents kind of are part of your financial planning and your estate planning. Now, there's also another type of power of attorney. It's called power of attorney for personal care. And that one we won't deal with at all. That one deals with issues concerning your personal care, such as your health, your shelter, your nutrition, your food. That document we won't talk about in the seminar because that one doesn't really concern you as real estate agents. But the power of attorney for property is something that you guys should all be familiar with, and we're going to go through that in more depth. So, do we have any questions so far? Is everybody kind of familiar with these documents? Okay. So let's move on. Okay, now we're going to talk about one special type of power of attorney. It's called a continuing power of attorney for property. Now, a power of attorney becomes a continuing power of attorney for property if it specifies that it can be exercised upon your mental incapacity. Otherwise, the power of attorney is a general power of attorney and will terminate upon your mental incapacity. So most of you are familiar probably with a continuing power of attorney. That one requires two witnesses, whereas a regular power of attorney or general power of attorney just requires one. Now, do you guys all see is this explanation clear to you all as to the difference between a regular power of attorney, like a general power of attorney, and a continuing power of attorney?
So, if you don't specify in the power of attorney that upon the mental incapacity, that it won't work, right?
That it has to specify in a power of attorney that upon your mental incapacity, it will still be effective. Then it becomes a continuing power of attorney.
Okay, but if you don't,
then it's just a general power of attorney, and that general power of attorney becomes ineffective upon your mental incapacity.
okay.
Now, for practical purposes, all powers of attorneys now are continuing powers of attorneys. I've not seen a general power of attorney for a long, long time, right? But
that one power of attorney, I don't think my lawyer put this clause in the statement there.
That's kind of odd. He should have.
Usually they would have, right?
Well, what happened is the continuing power of attorney only became legal in 1993.
No,
Before,
I just done it last year.
oh, okay. Before 1993, all powers of attorneys were general powers of attorneys. They weren't continuing powers of attorneys. It only became effective in 1993. So if any of you have really old powers of attorneys, like before 1993, they're probably general powers of attorneys. Okay. Now, let's talk about who can make a will and a power of attorney. Anyone who's at least 18 years of age or older and is mentally capable. That is very important. They must be mentally capable to give instructions in order to prepare a legal power of attorney. Once they become mentally incapable, let's say your client has dementia, Alzheimer's, and is certified to be mentally incapable, then he or she cannot make a power of attorney anymore. And the same with the will as well. Okay, now you guys are probably going to come across powers of attorneys at one point or another because a lot of your clients may be overseas and may not want to come back to Canada just to do a real estate transaction. So usually your client will go to a lawyer's office and sign a power of attorney so that power of attorney will then be used in your real estate transaction. Now, just a few pointers I want to point out. Both the will and a power of attorney made and signed in Ontario are effective in Ontario only and may not be effective in other jurisdictions. So the power of attorneys that you do in Ontario, like the ones that I prepare, I cannot say that it will work in the United States, in Europe, in China. I cannot certify that. I can only certify that the documents that I prepare here will be effective in Ontario only. And let's go through some terminology. In terms of the will, the person making a will is called the testator, and the person making a power of attorney is called the grantor. And the person that's acting under a will is the estate trustee, and the person acting under a power of attorney is known as the attorney. Okay, so far we're good. Everybody is kind of, any questions at all? Okay, so let's go on. Both the will and the power of attorney require two persons to act as a witness to either the testator or the grantor's signature. Note that certain persons should not act as a witness. So the attorney or the estate trustee should not act as a witness. The beneficiary should not act as a witness. The spouses of the estate trustee or the attorney should not act as a witness as well. Now, I won't go through the legal consequences of why they should not act as a witness. Just note that certain people cannot act as a witness to these documents. Okay, and then we'll go on. Both the will and the power of attorney can be revoked, but the revocation should be in writing. It's not sufficient just to tear up the document. Okay, you have to actually have something in writing to say that the will or the power of attorney is revoked. And this is very important. Both the will and the power of attorney must be signed freely without duress or undue influence. So it has to be signed without any pressure from anybody. All right, that's very important because a lot of times you have a family situation where one of the children would pressure the parents to sign either a will or power of attorney, and to give them everything, like to give them the control of the grantor's properties, or maybe to receive all the properties upon that person's death. But those documents will be challenged, could be challenged in court later on. Right? So it's very important you keep this in mind when you are acting as real estate agents and you're coming across a power of attorney. You got to make sure that the power of attorney or the will itself it's signed without any duress or undue influence. Do you all know what duress or undue influence, what it means? I'm sorry?
Threaten.
Kind of, yeah, kind of. It's for undue influence, it could be that you have an elderly person who is always being told by the child, you must sign this or otherwise I'm going to leave you, or I'm going to stop taking care of you. That sort of pressure could count as undue influence. Okay, so let's move on. The power of attorney can deal with all, some, or one of the grantor's properties. Now, as real estate agents, if you come across a power of attorney, it's most likely you're going to have the power of attorney just to deal with that particular real estate that you're dealing with. But it could deal with all of the grantor's properties. I mean, there could be no conditions on the power of attorney. But when I'm asked to prepare a power of attorney for a real estate transaction, I always prepare it for that particular property. So that way, the attorney doesn't have free reign over all of the grantor's properties. Do you follow what I'm saying? Now, the properties we're talking about can include both personal properties, such as bank accounts, stocks, and cars, as well as real estate. As well, the will can also deal with some, all, or one of the testator's properties. But for the most part, most people will want to give everything that they own at the time of their death. So usually the will include all of the testator's properties. Okay, so are we all familiar? Like, is there any questions right now? Anything that you guys may want to ask about? Now, I know we're just talking basically about some of the characteristics of wills and powers of attorneys. I'm going to get to the practical points later on, but I just wanted you guys to have some ideas as to some of the characteristics of these documents. Now, in a will, the beneficiaries, who are the people who are entitled to receive the testator's properties, are usually the testator's relatives. So most of the time, in a common family situation, the testator will give everything to his or her spouse first, and then when the spouse dies, when the second one dies, they will just divide everything up among their children. So that's the most common type of will that I get, or the most common type of instructions. Now, in a POA, although it's not named, you can really consider the beneficiary to be the grantor, because the attorney is only acting on behalf of the grantor. The property and the assets still belong to the grantor, but for some reason the grantor cannot deal with those assets or properties because he or she is away, like physically away from Ontario, or he or she is mentally incapable. But the attorney is still duty bound to act in the best interest of the grantor. And the attorney cannot treat the property as his. The properties and the assets still belong to the grantor, and the attorney is only appointed to deal with those properties and assets in the best interest of the grantor. Okay? So in a POA, the beneficiary, the person who's really entitled to receive the benefits, is really the grantor. Like I said, the attorney must always act in the best interest of the grantor when exercising the power of attorney, and can be required to account for all transactions conducted through the power of attorney, the POA. Okay, and lastly, both the attorney and the estate trustee are entitled to compensation in acting as an attorney or estate trustee. Normally, it's 5% of the estate value, or the value of the grantor's properties and assets. Okay, so do you have any questions so far? Is everybody?
Okay. Say like POA is only active before the person died, right? So can you override it with the will? On the will, can I say that even I pass away, the POA still?
No,
Or
legally,
no,
the
you
POA is finished. The POA is finished once, legally it's terminated once the person dies, the grantor dies. Yeah, once the grantor dies. Okay. So some of the special clauses you can insert into a will include the following. You can have a clause to set up trusts for the testator's minor children. So let's say, for example, the testator has very young children, like maybe say 5 or 6, for example, and the testator passes away. Obviously, you don't want the testator or the testator's properties and assets to go directly to the children because they're very young. So what you need to do is you need to set up a trust where the estate trustee would hold the properties in trust for the benefit of those children until they reach the age of majority, which is 18. Okay. And you can also have a clause to exclude the testator's assets from becoming part of a beneficiary's net family property in the event that beneficiary separates from his or her spouse. So the properties that the beneficiary is receiving will not be counted towards his or her net family property and would be excluded from the legal entitlement of that beneficiary's spouse. So it won't count towards the pool of assets of that beneficiary. Do you all understand what I'm? And you can also have a clause to exclude illegitimate children from sharing in a testator's estate. Right now, all children by law are treated equally, whether they're legitimate or illegitimate. By illegitimate, I mean born outside of marriage. Okay, so all children are treated equally. Now, the testator may not want illegitimate children to receive the estate. So you can have a clause to exclude children who are not born within a marriage from sharing in a testator's estate. Okay, what happens if a person becomes mentally incapable and does not have a POA? Okay, then we have a lot of problems. That person would have to be assessed by an assessor to see if he or she is incapable of managing property. If the person is found to be incapable of managing property, a certificate is issued by the doctor, and the public guardian and trustee, basically the Ontario government, becomes that person's statutory guardian of property. So basically the government would become that person's guardian of property. Then what you would need to do is you would need to have an application to be made to the public guardian trustee to replace the public guardian trustee as the incapable person's statutory guardian of property. And you also have to have a management fee, a management plan, and you have to pay a fee. The fee, I believe, is about $380. But the documents to prepare up the application and the management plan are very, very difficult to do, like very difficult. They're very long, very cumbersome. And it would take, and they're very intrusive too. I mean, they want details about the incompetent person's assets and properties. So they want a lot of details. It's very intrusive. You have to disclose basically all of the properties that the mentally incapable person owns. So this would all be solved if you had a power of attorney or continuing power of attorney. Because in that case, the attorney would just step in and would take over and would be able to deal with that mentally incapable or mentally incompetent person's assets and properties without going through this procedure. Now, I've actually done one of these before. I've done once in my career. I've actually made an application to the public guardian trustee, and the fee for that was roughly about the legal fee for doing that was roughly $2,500. So
who can be the PGT?
that's the government.
That's only from the government.
Yeah, there's a agency that's part of the Ontario government. It's called the Public Guardian Trustee. They step in these type of situations.
How much they charge?
They charge quite a bit of money as well to do the.
According to the hours or according to the percentage?
The last time I did one, I believe they charge based on the value of the estate. So
The what?
5%.
I'm sorry.
5%.
5%.
That's right.
Wow.
Excuse me, in a normal situation, does it need it or not? Like, for example, a family, they have, a house and they have money, and husband and wife both have, access, and they can, buy and sell the house or work with the, assets. So in that case, if one of the, spouse, become mentally incapable, the other one, without having POA or anything,
Cannot
have
act.
all the assets? Or
No,
it
cannot
goes
act.
to government?
You still have to go to the PGT.
Yeah?
Yeah, that's right.
But the family house,
Without a POA, without a POA then.
without a POA.
Oh yeah.
I mean, the family house belongs to both husband and wife.
No, because most people have that misconception that the spouse can just step in. That's not the case. You have to have a power of attorney in order to allow that spouse to deal with the mentally incapable spouse's assets. Otherwise, you have to go through this procedure.
But nobody knows that this is something all of a sudden that somebody becomes mentally capable and they don't have POA. It's not gradual. So nobody knows that this could happen, that they would prepare a POA.
Well,
That's why I thought that in a normal situation, you don't
excuse me.
but you say you do need it in any.
You need it. You need it. It's part of the estate planning process. Part of the process where you're planning in the event that something happens to you and you cannot deal with your properties and your assets. So a lot of people know what a will is, but most people don't know what a POA is. And with the population getting older and people living longer, it's just a matter of time before you run into situations where people become mentally incapable and don't have a POA, then you have to go through this procedure.
But what if it's a matrimonial house?
That doesn't matter
Why?
because you need the mentally incompetent person to be able to deal with that property. He or she cannot deal with the property. He or she doesn't have the capacity. And the spouse doesn't automatically become that person's attorney. Okay, you still need a POA. So in almost all situations where clients come into me and say they want a will done, they also get POAs done as well. Now, it could be that you may never come across a situation where that person becomes mentally incapable. Like that person may always, be of sound mind. In which case, you may not consider a POA to be necessary. But it just takes care of the situation where that person becomes mentally incapable. And like I said, with people living older now, like living longer, the possibility that they become mentally incapable during some part of their lifetime increases. Okay, so do you all understand? Like, do you guys have any questions at all? Like anything you not?
Do you have a real case you have deal with? You can share to us. Maybe it's more clear for us to understand the process.
No, not too long. Actually, I had a case from your brokerage just about a couple months ago, where an agent came up to me. I mean, I can disclose this because I don't know I don't know the names and stuff. I don't know who people are. So, just kind of a generic situation. But that person owned title with his mom as joint tenants, but don't have a POA, and that the mother now is mentally incapable, has severe dementia, and they want to sell the real estate. And I told them they had to go through this procedure, apply to the PGT, and pay the legal fees and pay the application fee as well, and go through the management plan and the application. You can actually take a look at the application yourself. Like just Google public guardian and trustee, and just Google application for statutory guardian of property. Then you can find out for yourself how long that application is.
I just comment on that. If they have wills, but if the people pass away, they still need the POA.
POA is only effective before that person dies. Once that person dies, then the POA is terminated and the will becomes the effective document. The reason I'm talking about the will and the power of attorney is because most people know what a will is, but they don't know the advantages of having a POA as well. This is why I'm going through this right now. I want to combine the two together so you know, like they complement each other. The two documents that complement each other. One takes effect if that person is still alive, but is mentally incapable or physically unable to deal with the properties. Let's say that person goes back to the Far East and has properties in Ontario. Usually, I would recommend that that person also do a POA while they're still in Canada, like in Ontario. So that way, they don't have to fly back from the Far East to Canada to sell the real estate, for example. Their attorney can take care of that. Okay, so either the POA is effective if you're mentally incapable, or if you're physically unable to deal with your properties and assets. And then once you die, then the will becomes the effective document.
Normally, how much charge for the lawyer for this post?
It depends on the instructions of the client, but normally for a will, it's normally about $175, and for POA, it's about $100. Yes, right.
$175.
For the will, and about $100 for the power of attorney. Now, I didn't talk about the power of attorney for personal care. That's a separate document. That also should be done as well. But I'm not talking about it in this seminar because it doesn't really concern you guys as real estate agents. Okay, do we have any other questions?
I just want to make it clear. So the old couple own the property, but right now the husband has their mental illness right now. So even now, the wife cannot handle the selling of the property, right? She must have the POA in order to be able to manage all the transactions.
That's right.
Okay.
That's right.
Okay. Thank you.
Okay, like I said, the application is a very long document, which is very time-consuming, intrusive, and expensive to complete. Okay, and if the application is not successful, let's say the public guardian trustee does not want the person who's applying, the applicant, to replace it as the guardian of property, then you would have to apply to the courts to be appointed as a court-appointed guardian of property. And with a POA, upon a certificate being issued by a physician, certifying that that person is mentally incapable, the attorney can proceed to deal with the mentally incompetent person's properties and assets without applying to the PGT or to the courts. So that's just a little bit of a background as to the advantages of having a POA. The other advantage is that as real estate agents for having a POA is that a lot of times your clients are overseas and they don't want to fly back here just to do a real estate transaction, right? Because it's expensive and it takes up time. They have to be away from work. So a lot of times you can use a POA to sell that person's property and still be able to close the transaction without that person having to come back to Canada. Now, I think that's probably the case. That's probably the most familiar use of the POA that you guys are aware, that you guys come across, right? But you also should be aware that if you have elderly clients, you should recommend to them to get a POA done as well, just to prevent the situation that they cannot later on sell their property because they became mentally incompetent, and they have to go apply to the PGT or to the courts to sell their real estate.
If they don't have the POA but they have the will, then wait until they die, the person that the test die, then you don't need a POA. Automatically you go to the will. Then the executor will sell the property.
Well, a lot of times, if it's a married couple, the property will be gifted to both the husband and the wife. The names will be on title, and will be on jointly. So, if one of the spouses dies, then the other one just automatically gets the entire property, right? Then you don't even need to go through a will. We'll talk about that a little bit later on.
Then you don't need the POA, right?
Well, yeah, but a lot of times people can live for a very long time and still be in a mentally incompetent stage, right? I mean, I've known people who are mentally incapable but have lived for like 20 years, right? So, I mean, it's just you can solve this problem very easily just by having paying $100 and having a POA done, right? Then you don't have to worry about these issues at all.
For the POA, can you make it effective for 20 years?
You can have it so that it's effective for a certain period of time. Yes,
Even for 20 years.
that's right. But I mean, if you're worried about the mental incapacity part, you don't want to have an effective date, right? Like, because you want it to survive for as long as possible. Okay, and this might be of some concern to you guys as well, because we're now going to talk about the case where if a person dies and does not have a will. Some of the consequences include the estate trustee and the beneficiaries are determined by law and not by the testator's wishes. So if the person dies without a will, then the law will determine who will act as the estate trustee and who will be the beneficiaries. Okay, the testator's wishes are not. The testator, yes?
What happens if they have no children?
Then it goes all to the spouse.
Sorry?
It goes all to the spouse.
No children.
Then it all goes to the parents.
Go to the parents.
And if no parents, then it goes to the brothers and sisters. Yeah.
Can they designate a person's
I'm sorry, can you speak up?
relative, a closer relative, like
Can you speak up?
brother and sister?
I'm sorry?
Can the person before they die, they have to go to the closest relatives,
They have to go to the.
closest members of the family. So if there no parents, no children, no wife, then who is it going to, government or
No, it's going to the brothers and sisters.
brother and sister?
That's right.
So of which side? Let's say the wife's side or the husband's side?
Well, the deceased person's side. Like whoever, like the
Survival. Okay.
yeah.
How about if the brother sister not?
Then it goes to the nieces and nephews, and then it goes on and on. But it gets very complicated. So
But if they're all in China or in Hong Kong, the government cannot get in touch with them. What to do?
even though they're overseas, even though the beneficiaries are overseas, they're still entitled to receive the properties. Like, okay, and also without a will, the probate process will take a considerably longer time. There will likely be more procedures to follow, and the cost to obtain probate will increase significantly. So the difference between the legal fees and the disbursements for doing probate with a will, the difference, I'm saying, for probate with a will and without a will, the difference in legal fees and disbursements may be about as much as $5,000. So the will itself is $175, and you're already saving on the probate fees or the legal fees to get probate by, as much as $5,000.
What is the probate?
Probate is when the person that's named in the will as the estate trustee applies to the court to have authority from the court to deal with the person's properties and assets. That's required if the deceased person has large bank accounts, has real estate that's only in his or her name or sharing with somebody else as tenants in common. We'll go through that in a few moments. And a lot of times in the will, you can appoint a guardian to look after any minor children. So any minor children under the age of 18, you can appoint a guardian in your will. And if you do not have a will, the court process to appoint a guardian for the minor child or children will take longer time and be more complex and expensive because the court does not know who the testator wants as the guardian. Right? If you name the guardian in your will, the court will usually just rubber stamp and say, fine, we will let that person act as the guardian. But if you don't have a will, then nobody knows who you want as the guardian. Then the procedure becomes more complicated and there's more inquiries that will be made. So that's kind of like, oh, yes?
Is it legal to name a will of a person that's not related to that, like a friend?
It's a...
Let's say a person, right? They have no any family, so by himself, and then he make a will to his friend.
You can appoint anybody to be your estate trustee. You can appoint anybody to be your beneficiaries. Like, it's all up to you. But just be aware that if you're separated from your spouse and you have a will that basically gives the spouse nothing, just be aware that the spouse still has rights under the Family Law Act to half of the net family property of the testator, right? So if you and your spouse are separated, you should have a separation agreement in place to exclude that spouse from sharing in your estate. Right? You need to have a separation agreement. A lot of times I see people come into my office who are separated from the spouse, and they say to me, "Oh, I want to do a will, and I want to exclude my spouse from having any entitlement under the will, like can receive nothing." But I tell them, well, it doesn't matter even if you have the will, because by law, that person still has rights under the Family Law Act to go after your property. So you need to clean up your separation by having a separation agreement. Okay.
So you have to specify on the separation agreement to exclude that they will go after the property even after.
Yeah, that's right. Most separation agreements have that as a standard common. But a lot of people, they don't want to go through the painful process of separation, right? They just separate, but they don't want to actually deal with the separation issues. But then they come into me afterwards and say, well, I'm separated from my spouse. I don't want to give my spouse anything. I want everything to go to my kids. Can I do that? And I say, no. The will, it doesn't matter if you have a will or you don't have a will. Your spouse still has rights under the Family Law Act to go after your property.
Legally, they're not separated.
Well, they are separated.
If they haven't gone through the legal process, so legally, they're not.
Well, you are separated as a matter of fact. Like you and your spouse.
Together, but then
Yeah, you and your spouse are physically separated, but you just haven't gone through the legal procedure to get a separation agreement done.
So, what's going to be the cost for the separation agreement on top of the wills?
Well, the separation agreement,
Yeah.
it's done. It's basically the legal fees will be done. It's it's calculated based on the time spent. So it depends on how long it takes to negotiate and finalize a separation agreement. So it could be as low as $750 to as much as $5,000. Okay.
So how do you determine the legitimacy of the POA? Say I can write a POA, or anybody can write a POA, as long as the two, like you mentioned, the witness.
Well,
I have to go to the lawyer or to get
because the POAs have been misused quite a bit in the past. If you're doing a real estate transaction, you better make sure that the POA is done in a lawyer's office, because the lawyer has certain obligations and make sure that that person who's signing is actually the person that's like the grantor, that person signing. So they have to verify that person's ID, and they also have to make sure that there's no undue influence or duress being put on the grantor to sign a POA. So
yeah, from a lawyer, there's no question asked, but I just asking the person to person, can it write it? Does it like legitimate for the person to write?
Well, legally, it would still. There's no requirement that a lawyer be a witness to the POA or prepare the POA. But I'm just saying that you're going to get a lot of questions asked, and you may not even have your real estate transactions completed if it's not done in a lawyer's office, because the buyer's lawyer may be very suspicious and even the title insurance companies may be very suspicious. You know, like they want to make sure that that POA is done in a lawyer's office. In fact, for myself, I probably wouldn't close the transaction, or I would ask a lot more questions if I saw a POA that was not done in a lawyer's office. I mean, it's not that expensive. Like most lawyers charge, I don't know, $75, $100, or it's $6. Like,
How about notary public? Like you make a.
well, most lawyers are notary publics, so.
I
Yeah.
mean, like the difference is not that much done by the lawyer.
It's very hard to be a notary without being a lawyer. So most notaries are lawyers as well, yeah. Okay, are we good for time here, or how much? Because I still have a few more slides. So we have about 20, 25 minutes? Okay. Okay, and without a will, the deceased person will not have the benefits of the special clauses that we discussed earlier. Okay, like the clause to exclude illegitimate children, the clause to set up trusts. So those clauses would actually make the testator's estate more efficient and less time-consuming and less expensive to administer. So the will itself has those clauses that will really benefit the estate. Okay, do you recall the clause we talked about earlier about the trust clauses, the clauses to exclude illegitimate children? Okay, those are standard clauses that you put into a will. And if you don't have a will, you kind of don't have the benefit of those special clauses. Okay, now we're going to talk about some practical tips for real estate agents when you come across a situation that involves either a will or power of attorney. In the event of an owner's death, examine how title is held to determine how to deal with that owner's real estate. If the owner held the property with someone else as a joint tenant, then title will automatically vest or transfer in that other person upon registration of a survivorship application. So basically, you just had to register the death certificate on title. Then the surviving person, the surviving joint tenant, would receive the whole property. It's a very simple and easy process. And I think the cost is about roughly $300, $350. But it's a very simple and cheap procedure. Okay.
Can I ask a question?
Mm-hmm.
I have a scenario that, like a client, he's in a hospital in a critical condition, and his wife and he owned the property jointly. So can his wife sell property?
Not right now, not until he passes away.
But his wife has POA.
His wife does have a POA?
Yeah.
And that POA is a
Is for property. POA for the property.
and it has no restrictions or conditions, does it?
I'm not sure.
I would have to look at the document, to let you know. Like I have to take a look at the POA to make sure.
There's certain details inside to indicate that she can sell the property.
Well, I would have to look at the document in more depth. Like I don't know whether there's any conditions put on the POA. The POA may also have expired as well. Like there may be an expiry date, so I have to take a look at that as well.
So if no will, the joint account, the bank joint, the house joint, the title is automatically go to the people's will left.
If the real estate is held as joint tenants,
A no will.
that's still fine. You just need to register the death certificate on title. Then the title to the property will automatically transfer to the surviving joint tenant.
Still need through the lawyer to do this.
Yeah, you still need to go through a lawyer for that. It's about roughly $300 to $350.
So just when people die, then the people left, the wife or husband, just find some lawyer to do this kind of issue.
Yeah, it's called survivorship application. But it's a very simple and easy process. It could even be done within a day, right? So it doesn't stop your real estate transaction, because all you need to do is just to remove the deceased owner's name from title by registering the death certificate on title, and then that's it.
Any transfer tax? No way.
No, there's no tax. No tax on a.
So what about if like a couple, the house title is only under one person?
Well, we're going to get to that the next scenario. If the owner held title as a sole owner or as a tenant in common with another person, now tenancy in common is the situation where each owner owns a specific percentage of the property. It's not held jointly. So it could be something where Tony owns 50% of the property and I own the other 50%. In those two cases, then you would need to obtain probate in order to deal with that property within 3 years of the owner's death. So you need to go through the probate process in these two cases. Whereas in this case, all you need to do is just register a survivorship application, and that's it. The property automatically goes to the surviving joint tenant. So if you're asked to act on the sale of a real estate or of real estate, and you know one of the owners may have passed, or the owner may have passed away, then you need to go through this analysis to figure out how to proceed. Or you can just call your lawyer and ask him to figure it out, right? Yes?
Yeah, I have a question for the joint tenant. For example, husband and wife, when the wife died, then the husband go for the lawyer for the
Survivorship application.
My question is on they put the property to sale on the agreement person sale is on the husband's name only, or both names have to go on the.
No, because that only the surviving spouse.
Only the survival on.
Yeah, because once you register the survivorship application, it's a very simple procedure. The deceased owner's name will come off title automatically.
Excuse me, if two people are investing in a house, so not husband and wife, as you mentioned, like you and Tony, like 50-50 or whatever, what is the best way of doing this? So until they are doing this investment together, for example, they buy a property, they rent it and all that, so is it better to do tenancy in common or do the joint tenancy?
No, you should have tenants in common in that case.
But then if something happens to one of the partners, the other one has to go through the probate process.
Yeah, that's right.
It's a
That's the yeah.
It's a lengthy process, right?
It can be a lengthy process. It depends up to the court. Like you can't rush the court and tell the court hurry it up. Like it's up to it's up to the court to give you the probate. And sometimes the probate process could take 1 to 2 months, and sometimes it could take 5 to 6 months. But I can tell you that if you have a will, the probate process is much faster and much cheaper than without a will. Okay, do you have any? Yes?
How long does it take if a person have a will, they die, do they have to change the property name right away to that person, or no? Or they could just leave it as is?
Well, they should really clean up title. I mean, there's no specific deadline, but they should really clean up title and get the deceased person's name off title. So they should do it as soon as they can, right? Like,
Because I have a client like that, and they don't want to, I ask them, they want to start the property, but they don't want to change their wife has to bother to change the name to his name, you know.
you mean, I don't understand. You're saying that it's a situation where one owner has died?
No, it's not the owner. It's the person died had no relative, no member, no family member. So he named the friend as a, he take the friend as a family member. He named the property, like her property as the person died, and leave the property to the friend. And
Well, what do you mean leave the property to a friend? Through a will?
The will appoint the friend as the beneficiary.
Executor.
As the owner, as the new owner. If he died, then the next is. But he refused to change the name. So
Well, the title will stay in the deceased owner's name until something is done, until you get probate, and then you do a transmission application to transfer title over to that friend.
is there an expiry date for the transfer owner name?
There is no expiry date, but that should be done as soon as possible. Like, you shouldn't leave it in the deceased owner's name for that long. My suggestion is to get that done ASAP.
Because he say that my bother to
Well, it doesn't matter. He's got to do it sooner or later. He's got to do it eventually anyway. Otherwise, his name will never go on title.
he wants to do it when he starts the property. He wants to start that property.
Well, the problem with that is that, like I said, probate could take 5 to 6 months, and they could ask a lot of questions, right? Why don't you do it now while you're not selling the property? Just be prepared. So once you sell the property, all that legal work has been done, and you don't have to wait for probate, right? Because, like I said, probate could take 5 to 6 months. So if he wants to sell it now, he still cannot transfer title to the buyer until after probate has been obtained.
They charge 3%, right?
We'll get to that in a sec. Okay, I'm just going to finish up because I think we are kind of close to the time. We have. Okay, now we're going to talk about the probate fees. They're formerly known as the estate administration tax. Oh, by the way, if you ever hear the word executor and estate trustee, they both mean the same person. Okay, in the past, the person who was administering the estate was known as the executor, but now they have changed that name, so now they're known as estate trustees.
When did they change?
Oh, 1995, a long, long time ago, yeah. Most people still use executor, but it's interchangeable. Estate.
I saw a will of my friend that still use executive.
Yeah, that's.
So it's still.
No, but I mean, it's interchangeable. You can use it one or the other.
So you do the trustee and the executor are the same.
Well, actually, the executor and the estate trustee, it really should be estate trustee with a will. Because you could be an estate trustee without a will as well. Okay? Now, fees are payable at the time of applying for probate, and probate fees, which are formerly known as the estate administration tax, are payable as follows. There is no estate administration tax payable if the value of the estate is $1,000 or less, which will probably be me, but I think most people will die with more than $1,000, hopefully. For all other estates, for anything that's over $1,000, the taxes apply at the following two rates: $5 for every 1,000 or part thereof of the first 50,000 of the value of the estate, and then $15 for every 1,000 or part thereof of the value of the estate exceeding 50,000. So I just did a simple calculation. So the estate administration tax payable on an estate with a value of $1 million would be $14,500. Now you see the calculation I did? So Now, starting January 1st, 2020, the Ontario government is proposing to eliminate the estate administration tax on the first $50,000 of the value of the estate. But it will still continue to apply to the value of the estate exceeding $50,000 at the current rate. So the tax would simply be calculated as $15 for every 1,000. So basically 1.5% of the value of the estate. Over 50,000, yeah. Okay, so, just some pointers I want to point out to you about situations where you're acting on an estate sale. I have noticed that some real estate agents have proceeded to sell a property conditional upon probate being obtained. This is risky since the time to obtain probate is uncertain, and there may be disputes between the beneficiaries which would delay probate as well. So a lot of times I see agreements where the closing date is conditional upon probate being obtained, but we don't know when that is. And that's quite a bit of that's caused a significant inconvenience for the buyer because they don't know when they're going to be closing the deal. So
normally we need to put this as buyer, we have to put this clause.
well, it's better if you can get your client to proceed to do the probate as soon as possible, right? If they know they're going to sell the property and they know that the owner is, like the owner is deceased, they should start the probate process as soon as possible. And the other thing that I see on agreements is that you, the seller in a estate sale transaction is misnamed. Okay, it really should be, it's really the name of the estate trustee. So it should say John Doe as estate trustee for the estate of, and then the registered deceased owner. That's the proper way to name your seller in an agreement.
How about power of attorney? What's the reason?
No, the power of attorney is still the name of the owner, but you just say, when you sign it, you just say, attorney, acting as attorney for registered owner.
All the signing, all the signatures should sign.
Or in this case, the estate trustee signs on an estate sale, and in a power of attorney situation, the attorney would sign the agreement. But you should just identify that it's the attorney who's signing the agreement. So it should really have his name underneath the signature line, saying attorney, acting as attorney for, and then the name of the grantor, the name of the registered owner. Okay? So that's really the proper way to name the seller in an estate sale. Now, you need to, if you have an estate sale coming up, you really need to review the terms of the will to ensure that the property has not been specifically gifted to a beneficiary and that the estate trustee has the power to sell real estate. I mean, what I recommend is that you probably should consult with your lawyer about the will and just make sure that the will allows the estate trustee, the executor, to sell the real estate and that the real estate hasn't been given to a beneficiary. All right?
So what thing is gifted for a beneficiary?
Like somebody may, a testator may have, say, I want to give my property to my eldest son. In that case, if that's in a will, then obviously that property can't be sold, right? Because it's got to be gifted to the older son, for example. So you just have to make sure that the will doesn't have a specific gift clause that gives the real estate to one of the beneficiaries. Do you follow?
Okay, if that kind of person, okay, we need to avoid that kind of for sale.
Well, you need to check the will and make sure that the real estate hasn't been specifically gifted to a beneficiary. Because some people, they actually do gift the real estate to a beneficiary upon their death. Like I have had situations where the testator say, I want to give my condo to my older son because the other son, I give a property to the other son during my lifetime. So they left the condo upon their death to the oldest son, for example, and you can't sell that real estate. That real estate's got to go. That condo's got to go to the oldest son. So just make sure that.
The older son can sell, right? The older son, you go to the older son and the older person can sell it.
Yeah, but the oldest son may not want to sell it. May want to keep the condo. It's not available for sale unless the oldest son wants to sell it, right?
So how does the tax calculated for that gift, the property that goes to the son? Is there any tax?
It's the same. It's what we just talked about, the estate administration tax. You pay that tax on the whole value of the estate. And then once you pay that tax, that's it. You don't pay another tax.
And when he sells the property, it's his own or the son?
Well, no, but I mean, if it's not his principal residence, it may not be his principal residence, right? Then he's got to pay capital gains tax on that.
From the time that he received to the time that he's selling?
You had to talk to an accountant about that. Like, I'm not really clear about the tax implications. But there would be tax if it's not his principal residence.
Because if there's a gift, it will be zero value, right?
No, it would be gifted to him at the fair market value at the time when he receives the real estate. So, now also keep in mind that the estate trustee does not have any knowledge of the property. So make sure you don't include any warranties, like, for example, no debts in the property, the chattels and fixtures are in working order, or that there are no work orders, or declarations such as a survey declaration in the agreement of purchase and sale in an estate sale. All right, so make sure no warranties, no declarations, and so the agreement should be very clean. Okay, that's just common sense, right? So, because a lot of times the estate trustee doesn't have any knowledge of the property. It's okay. And lastly, I just want to go through the tips about the use of the POA. Okay, most important is don't draft the POA yourself. Don't do that, okay? Like, always get a lawyer to do the POA. If you do the POA, then there may be some problems for you.
Sorry, Service Ontario, they have the official.
Like I said, don't draft the POA, okay? Okay, don't draft the POA yourself. If anything, if you don't draft it properly, if you included one of those witnesses that you shouldn't have included, right? It's going to cause a lot of problems for you. If the POA was not signed in a lawyer's office, ask why not. Like I said, almost all the POAs I see that are being used in real estate transactions all have been done by a lawyer. Do not act as an attorney for your client. If you act as an attorney, you have a lot of obligations and a lot of liabilities. So I recommend you do not act as an attorney. I don't know, what's your brokerage policy on that? Can a real estate agent act as an attorney?
Tend to avoid.
Huh?
Tend to avoid.
Try to avoid?
Avoid. Don't get someone else if there's
Okay.
unless there's no one.
I don't know. Would that be covered by the real estate agent's ills and omissions insurance if you act? I don't think so, eh? No, eh? No. Okay, so do not act as an attorney for your client. Be aware of any suspicious circumstances surrounding the POA, such as duress or undue influence.
What's the risk in that?
Because you're acting as an attorney and you're also acting as an advisor to the owner, you have a very high standard you got to meet, very high standard. So you got to make sure you act always in the best interest of the clients. You have to make sure that, if there's conflicts, you have to make sure that there's no conflicts. So acting as an attorney gives you additional obligations and additional liabilities. I mean, I don't want to go through the details here, but just to let you know that you are exposed to more liability and more liabilities and more obligations if you act as an attorney. Okay, I don't want to go through that now, but just be aware that if possible, don't act as an attorney for your client. Like I never act as an attorney for my clients. like the clients have asked me, do you want to act as an attorney or an estate trustee? I said no. Keep in mind that the attorney should be someone that the grantor has a high level of trust and confidence. Well, that's kind of obvious, right? Like the attorney is going to be acting for the grantor, right? So you want to make sure that the attorney is trustworthy and honest. If you are required to act as an attorney, which I do not recommend, you should always get instructions from your client before proceeding. Okay, and that's just common sense as well. And you have to make sure that the attorney is prepared to act. The attorney is not under an obligation just because he or she is named any power attorney to act as the attorney. So you should always consult with the attorney and make sure that they're prepared to act. If they're not prepared to act, then the power attorney is really ineffective. Tell your client that he or she will need to provide photo ID when he or she makes the power attorney. The POA should be expressly limited to the real estate transaction in question. Do not make the POA broad in nature to avoid any misuse. So it should not be a power attorney without any conditions or restrictions. It should just be restricted to that real estate transaction that you're dealing with. And also the POA should also be expressly time limited, i.e. the POA should expire on a certain date to avoid any misuse. And this is the proper way of preparing the agreement or having the agreement signed with the POA. The attorney should sign the agreement of purchase and sale, and underneath the execution line, it should say, John Smith, signed by Jane Doe under power attorney. And you should attach a copy of the power attorney to the agreement. And if the purchaser is arranging mortgage financing, make sure that the POA is approved by the bank or mortgage company before the deal is firmed up. Okay, a lot of banks and mortgage companies, a lot of lenders do not accept POAs. They do not allow POAs to be used to sign mortgage documents. So you really need to confirm that with the financial.
For the second, I have one question. So the POA is made in China, so and is effective and in Canada, in Ontario, or should still used by the local Ontario lawyer?
Is it an Ontario power attorney and it was just signed in China?
The power attorney document is sent from China. They're made in China.
I don't think that would be effective in Ontario. No. So.
But the salary right now is in China, so they only use that.
They would have to come back to Canada to sign the document. I don't think, if it was me, I probably would not accept the POA if I was acting for the buyer. So it's actually, a lot of times you get the client actually, he or she is in Ontario, like in Toronto, to sign the documents for the purchase. Like when they bought the property, they will be in Ontario to sign the documents. At that time, I always recommend to them and tell them, look, you should have a POA and name somebody as an attorney to sell your real estate, so you don't need to come back to Toronto again when there's time to sell. So the client should have been made aware of that when they bought the property. Yeah. Like I said, keep in mind that the POA should be executed or signed in a lawyer's office in Ontario to avoid any potential issues during the transaction. And just be aware that on a real estate sale, the sale proceeds, after you deduct real estate commissions, your fees, lawyer fees, and mortgage payouts, will always be made payable to the grantor or the seller, not the attorney. So like I said, like remember I said that the grantor is really the beneficiary under a POA, right? In this case, the money, the balance of the closing funds will always be made payable to the grantor or the seller.
This should do by the lawyer. Should be done by.
Yeah, I'm just bringing it to your attention that, at the end of the day, after the real estate transaction is completed, the money will always go back to the grantor, not to the attorney. And that's where you get the misuse. Before, you had POAs that were misused. Like the attorney would get somebody to sign, forge the grantor's signature on a POA, would go to the lawyer's office, use the POA to arrange for mortgage financing, and then tell that lawyer, oh, make the money payable to me instead of to the registered owner, and then just take off with the money, right? And now the rule is the money after the real estate deal is done, the money is always given to the registered owner, never to the attorney.
Okay, here is, because recently I had one case.
Actually, let me just finish up here, and then I can talk to you afterwards. So.
We are already over time.
Yeah, so
Please wait a minute.
I think I just have one more. Yeah, I just have one more slide. So, okay, and also make sure that the POA has the correct name spelled correctly, has 2 witnesses, and is properly drafted. I can't tell you the number of times that I've seen POAs that are drafted in very poor English. I can't even make out what they're saying. Like it's really poorly done. So make sure that the POA is properly drafted to avoid any problems, like to avoid the POA being rejected. Finally, the use of the POA should always be the exception and not the rule. It should only be used in exceptional circumstances. Okay? So if your registered owner is in Ontario, is present, he or she should always sign the closing documents, never the attorney. Okay? Okay, and thank you.
Okay.
Thank you.
Peter's office is in the corner. So if you have any transaction, any question, feel free.
Actually, I can, is this room being used? I can stay here just to answer some questions.
Yeah, if anyway you have a personal question, you can ask Peter. But other than that, Tony is waiting you in the downstairs. Go downstairs, but only go to one floor.
One row.
Where is your